1.1 Criminal Law Reform Acts. Why in the news? President of India granted assent to 3 significant bills to overhaul the country's criminal justice system. More on the news. The 3 acts include O Bharatiya Nyaya Sanhita 2023 replacing the Indian Penal Code, IPC, 1860. O Bharatiya Nagarik Suraksha Sanhita 2023 replacing the Code of Criminal Procedure, CRPC, 1973. O Bharatiya Sakshya Adhiniyam 2023 replacing the Indian Evidence Act, 1872. The passage of the act was preceded by 3 bills to reform criminal laws. The bills were first introduced in the House in August 2023 during the monsoon session of the Parliament, and thereafter referred to the Standing Committee on Home Affairs. However, earlier bills were withdrawn and the new bills were introduced in December 2023, incorporating some of the suggestions of the Standing Committee. Need for reforms in criminal laws. Modernizing the criminal justice system, the IPC, IEA, and a large section of the CRPC are older than independent India and do not properly reflect current norms of criminal jurisprudence. Societal changes require an evolving and adaptable criminal justice system, e.g. integrating modern technology in evidence gathering, storage, etc. Addressing large pendency and timely justice, complex legal procedures, and a lack of resources have led to almost 4.7 crore pending cases in various courts and many under trials languishing in jails. Increasing conviction rates, the criminal justice system's inefficiencies, including inadequate forensic investigation, policing deficiencies, and the influence of powerful individuals on law enforcement, contribute to low conviction rates. Incorporating recommendations of various high-level committees, these include the recommendations of Law Commission, Mali Math Committee, 2003, and Justice Burma Committee, 2013, on aspects related to arrest, confessions, bail, death penalty, etc. 1.1.1 Bharatiya Nyaya Sanhita 2023. Objective Bharatiya Nyaya Sanhita 2023 replaces Indian Penal Code, IPC, 1860, the principal law on criminal offences in India. Background. Prior to IPC 1860, Indian criminal law consisted of a complex array of parliamentary charters and acts, East India Company regulations, Hindu law, Muslim law, customary law, etc. First Law Commission, 1834. It was created under Thomas Babington Macaulay to modernise laws and the colonial governance of civil society. It produced draft of Penal Code in 1837, which completely ignored existing Indian laws and instead was founded on British common law. Effective 1857 rebellion, formation of IPC was delayed for years, as it was undergoing multiple revisions. However, with the rebellion of 1857 and the British Crown taking over direct control in 1858, IPC was finally enacted in 1860 and came into force in 1862. Post-enactment of IPC 1860, over the years, the IPC has been amended to add new offences, amend existing ones and change the quantum of punishment. Several Law Commission reports have recommended amendments to the IPC on subjects including offences against women, food adulteration, death penalty, etc. Any foreign country. Organised crime. It defines organised crime as any continuing unlawful activity including kidnapping, extortion, contract killing, land grabbing, cybercrime, etc. carried by an individual or a group, either as a member or on behalf of an organised crime syndicate. Murder or grievous hurt by a group on certain grounds, when a group of 5 or more persons acting in concert commits murder or causes grievous hurt on the ground of race, caste or community, sex, place of birth, language, personal belief, or any other similar ground. Each member of such group shall be punished with death or life imprisonment, and a fine in case of murder, imprisonment for a term up to 7 years, and a fine in case of grievous hurt. Conclusion. Objective. Objective. The Bharatiya Nagarik Suraksha Sanhita 2023 replaces the Criminal Procedure Code, 1973, CRPC, which provided for the procedure for arrest, prosecution, and bail under various acts, including the IPC 1860. Background. Genesis. CRPC was first enacted in 1861 under British rule and later substituted by fresh codes successively enacted in 1872 and 1882. It had undergone several amendments, most importantly in 1898, 1923, and 1955. CRPC 1973, the Law Commission of India, in its 41st report, recommended a significant revision of the code, which led to the creation of CRPC 1973. Key provisions of Bharatiya Nagarik Suraksha Sanhita 2023. Detention of under trials. First-time offender, who have completed 1/3 of the maximum period of imprisonment specified for such offence shall be released on bond. If an accused has spent half of maximum period of imprisonment specified for an offence, he shall be released by the court on bail. 6 www. This does not apply to offences punishable by death, life imprisonment, and persons against whom proceedings are pending in more than one offence. Medical examination. Any police officer can request medical examination of the accused in certain cases, including rape cases. Forensic investigation. It mandates forensic investigation for offences punishable with at least 7 years of imprisonment. O. If a state does not have forensics facility, it shall utilize such facility in another state. Signatures and finger impressions. It empowers a magistrate to order any person, whether arrested or not, to provide specimen signatures, handwriting, finger impressions and voice samples. Timelines for procedures. It prescribes timelines for various procedures. For instance, submission of medical reports to investigating officer, giving judgment, informing the victim of progress of investigation, and framing of charges. Conclusion. Incorporation of forensic science, prescribed time limits for the police, lawyers and judges is expected to expedite justice delivery. 1.1.3 Bharatiya Sakshya Adhiniyam 2023. Objective. The Bharatiya Sakshya Adhiniyam 2023 replaces the Indian Evidence Act, 1872, IEA, which governed the admissibility of evidence in Indian courts in all civil and criminal proceedings. Background. Genesis. The Evidence Act was enacted in 1872 with a view to consolidate the laws relating to evidence on which the court could come to a conclusion and pronounce the judgment. Over the years, the IEA has been amended several times, most recently in 2000 to provide for the admissibility of electronic records as secondary evidence, and in 2013 to add provisions related to consent in cases of rape. Primary issue, the IEA did not address the technological advancement undergone in the country during the last few decades. Key provisions of Bharatiya Sakshya Adhiniyam 2023. Admissibility of electronic or digital records as evidence. It provides that the electronic or digital records will have the same legal effect as paper records. It expands electronic records to include information stored in semiconductor memory or any communication devices, smartphones, laptops, emails, server logs, etc. Documentary evidence. It adds that electronic records will also be considered as documents apart from writings, maps, and caricatures. Oral evidence. Oral evidence includes statements made before courts by witnesses in relation to a fact under inquiry. The Act allows oral evidence to be given electronically. Joint trials. A joint trial refers to the trial of more than one person for the same offence. The Act adds that a trial of multiple persons, where an accused has absconded or has not responded to an arrest warrant, will be treated as a joint trial. Conclusion. The three laws present an opportunity to truly decolonize the criminal justice system and uphold constitutional values in criminal processes. A framework for regular monitoring and periodic review of new criminal laws will also go a long way in modernizing the criminal justice system. 7W 1.2 Crime in India 2022 report. Why in the news? The National Crime Records Bureau, NCRB, released its annual report on crime in India for the year 2022. About the report. It is a compilation of data on reported crime from across the country and provides the big picture of broad trends in crime registration. As per the international standard, the Bureau follows Principal Offence Rule for counting of crime. If many offences are registered in a single FIR case, only the most heinous crime, i.e. the one that attracts maximum punishment, will be considered as counting unit. Key findings of report. Category findings of 2022 report trend compared to 2021. Other key information. Overall crime over 58.24 lakhs cognizable crimes were registered in 2022. Declined by 4.5% crime rate. Registered per lakh population has declined from 445.9 in 2021 to 422.2 in 2022. Crime against women over 4.45 lakh crimes against women in 2022. Increased by 4% dominant categories. Cruelty by husband or his relatives, 31.4%, followed by kidnapping and abduction of women, assault with intent to outrage her modesty and rape. Registered FIRs. Highest in Uttar Pradesh, followed by Maharashtra. Crime against child over 1.6 lakhs cases in 2022 increased by 8.7%. 39.7% cases were filed under the Protection of Children from Sexual Offences Act. Crime against senior citizens. Around 28,000 cases were registered in 2022 against senior citizens. Increased by 9.3% dominant categories. Simple hurt, 27.3%, followed by theft, 3,944, and FCF, forgery, cheating and fraud. Crime against SCS and SDS. Crimes against SCS went up 13% and against SDS by 14.3%. Increased 8.2% cases against SCS registered under SC/ST Prevention of Atrocities Act. 8WW. Cybercrime. Over 65,000 cases were registered in 2022 under cybercrimes. Increased by 24.4% categories. Cyber fraud constituted the majority of cases, 64.8% of registered cases, followed by extortion, 5.5%, and sexual exploitation, 5.2%. Among states, the highest number of cybercrime cases recorded was in Telangana, 15,297, followed by Karnataka and Maharashtra. Environment-related crime total 52,920 cases were registered under environment-related offences. Decreased by 17.9%. Majority of cases, 80%, registered under the Cigarette and Other Tobacco Products Act, COTPA, followed by noise pollution. However, the cases registered under Environment, Air, Water and the NGT Act has increased. Offences against state, a total of 5,610 cases, have been registered, increased by 8.6%. 78.5% of cases were registered under the Prevention of Damage to Public Property Act, followed by 17.9% cases under the Unlawful Activities Prevention Act. 1.3. Chief Election Commissioner and Other Election Commissioners ACT 2023. Why in the news? The President gave her assent to the Chief Election Commissioner and other election commissioners for appointment, conditions of service and term of office, Bill 2023. Key provisions of the Act. The Act replaces the Election Commission, Conditions of Service of Election Commissioners and Transaction of Business, Act, 1991. Aim. The Act seeks to regulate the appointment, conditions of service and term of office of the Chief Election Commissioner, CEC, and other election commissioners, ECS, and the procedure for transaction of business by the Election Commission. Selection Committee. The CEC and other ECS shall be appointed by the President on the recommendation of a selection committee consisting of Prime Minister as chairperson, Leader of Opposition, a leader of the largest opposition party in the Lok Sabha, Union Cabinet Minister to be nominated by the Prime Minister. Search Committee. A search committee shall prepare a panel of 5 persons for consideration of the Selection Committee for appointment as the CEC and other ECS. It is to be headed by the Minister of Law and Justice and comprising 2 other members not below the rank of Secretary to the Government of India. Eligibility. The Act specifies following eligibility criteria for appointment as CEC and ECS. Persons who are holding or have held a post equivalent to the rank of Secretary to the Government of India, and should be persons of integrity, who have knowledge of and experience in management and conduct of elections. Salary, term of office and reappointment. Salary. The CEC and other ECS shall be paid a salary which is equal to the salary of a judge of the Supreme Court. Term of office. The CEC and other ECS shall hold office for a term of 6 years from the date on which he assumes his office, or till he attains the age of 65 years, whichever is earlier. Reappointment. The CEC and other ECS shall not be eligible for reappointment. 9WW. Removal and resignation. CEC can only be removed from his office in a manner and on grounds similar to that of a Supreme Court judge. An EC can be removed from office upon the recommendation of the CEC. The CEC or any EC may resign at any time by writing to the President. About Election Commission of India, ECI, under Article 324, Election Commission of India, ECI, is an autonomous constitutional authority responsible for administering union and state election processes in India. It administers elections to the Lok Sabha, Rajya Sabha, state legislative assemblies in India, and the offices of the President and Vice President in the country. Constitutional provisions for appointments. Under Article 324(2), the President of India is empowered to appoint the CEC and the ECS. Article 324(2) empowers the President of India to fix from time to time the number of election commissioners other than the CEC. Concerns highlighted with the Act. Independence of the Election Commission. Selection Committee has a majority of members from the government of the day, which may undermine the independence of the ECI. The Act drops the Chief Justice of India from the Selection Committee, as was ruled by SC in Anup Baranwal case. Vacancy in Selection Committee. The Act upholds the validity of the Selection Committee even if there is a vacancy or defect in constituting the committee. The post of the Leader of Opposition in Lok Sabha may be vacant if Lok Sabha is dissolved. In such a case, the Selection Committee will consist exclusively of the Prime Minister and a Union Cabinet Minister. Undermining the role of Search Committee. The Act provides that Selection Committee may go beyond the names suggested by the Search Committee. This may undermine the role of the Search Committee, which is specifically constituted to look for capable and qualified candidates. Limiting eligibility criteria. By limiting the eligibility criteria of the CEC and ECS to civil servants, the Act may exclude other qualified individuals for the post. Lack of parity in removal of the CEC and ECS. The Act retains the existing lack of parity in removal of CEC and ECS. Silence over post-retirement jobs. Similar to 1991 Act, this Act too is silent with regards to the further appointment of the CEC and ECS to any post or office under the government after their retirement. Way forward. Balanced composition of the Selection Committee. Goswami Committee on Electoral Reforms, 1990, and 255th Law Commission report had recommended that Select Committee for choosing CEC and ECS should consist of the Prime Minister, the Leader of the Opposition of the Lok Sabha, and the Chief Justice of India. Post-retirement, Goswami Committee, 1990, had recommended that the CEC and ECS should not be eligible for any further office under the government, including the office of Governor. Administrative independence. Goswami Committee and the ECI have recommended an independent secretariat for the functioning of the ECI. Equal constitutional protection to all members of the ECI, as per 255th Law Commission report, Article 324(5) of the Constitution should be amended to equate the removal procedures of the ECS with that of the CEC. 10WW 1.4 Press and Registration of Periodicals ACT 2023. Why in the news? The President has granted assent to the Press and Registration of Periodicals Bill 2023 repealing the colonial era law of the Press and Registration of Books Act 1867. Brief History of the Press and Registration of Books Act 1867. Censorship of Press Act of 1799. Under Lord Wellesley, the act was to silence the press before a potential French invasion of India. However, it was retracted in 1818 by Lord Hastings. Licensing Regulations, Ordinance, 1823. Under Acting Governor-General John Adams, the ordinance had a draconian provision that no one could start or continue to use a press without registration. Ram Mohan Roy's Murat al-Akbar had to cease publication due to this act. Press Act of 1835. Under Governor-General Metcalfe, this act was seen as a ray of liberation, and thus earned Metcalfe the respectable title of Liberator of the Indian Press. As a consequence, the Indian vernacular press saw rapid growth across India between 1835 and 1857. The Licensing Act of 1857. Due to the revolt of 1857, this act emerged, which imposed licensing restrictions in addition to the pre-existing registration procedure. Press and Registration of Books, PRB, Act 1867. Under Viceroy Lord John Lawrence, the act made it mandatory for every article of print to have the names of the printers, publishers, and the places of publication printed. The primary motive of this act was to exercise complete control over the press, printers and publishers of books and newspapers. Further amendments. The act was amended many times between 1870 and 1983, but it remained procedurally cumbersome and complex, especially for small and medium publishers. Key changes between the PRB Act, 1867 and the PRP Act, 2023. Key provisions. Press and Registration of Books Act, 1867. Press and Registration of Periodicals Act, 2023. Registration of Periodicals. The 1867 Act provided for the registration of newspapers, periodicals, and books. Periodicals do not include books or scientific and academic journals. Books are outside the purview of the Act. Foreign periodicals. There was no provision for registration of foreign periodicals. A facsimile asterisk of a foreign periodical may be printed in India only with the prior approval of the central government. Asterisk facsimile means an exact reproduction of the original. Declaration for printing presses. The Act provided that a declaration specifying the printer or publisher be made to the district magistrate, DM. The DM sent the declaration to the press registrar, who then issued a certificate of registration. Act allows the publisher of a periodical to obtain a registration certificate by filing an online application with the Press Registrar General, PRG, and specified local authority. Registration of a printing press. The 1867 Act required a printing press to be declared before the DM. The PRP Act, 2023 allows for information regarding printing presses to be submitted through an online portal. Penalties. PRB Act 1867 had severe penalties leading to conviction and imprisonment up to 6 months for various violations of the Act. The 2023 Act seeks to decriminalize the colonial-era statute by replacing jail terms with fines. 11W. Cancelling registration. In the 1867 Act, only the DM could cancel the declaration of a periodical. The PRP Act 2023 empowers the Press Registrar General to suspend or cancel the certificate of registration. Also, a person who has been convicted of a terrorist act or unlawful activity, or has acted against the security of the state, will not be allowed to publish a periodical. Benefits of PRP Act 2023. Digitalization. The Act makes the process of allotment of title and registration of periodicals simple and simultaneous. Fast-tracking the process. Act enables the Press Registrar General to fast-track the process, thereby ensuring that publishers face little difficulty in starting a publication. The applications for title verification and registration have been combined to form a single step. Decriminalization. The new Act substantially decriminalizes all violations under the old one, thus shedding the colonial legacy. Provides clarity. The Act adds clarity on various procedures for cases such as facsimile editions of a foreign publication, circulation verification of newspapers, ownership transfer, and others. Conclusion. The 2023 Act is in sync with the present age of free press and upholding media freedom. It provides for digital governance with an emphasis on faster and more efficient service delivery through a troika of trust, transparency, and technology. 1.5. Telecommunications ACT 2023. Why in the news? The President gave his assent to Telecom Bill 2023 to replace the 138-year-old Indian Telegraph Act. More about the news. The new Act seeks to regulate activities related to telecommunication and provide a new legal framework for the telecom sector. The Act replaces the Indian Telegraph Act, 1885, the Indian Wireless Telegraphy Act, 1933 and Telegraph Wires, Unlawful Possession, Act, 1950. It also amends the Telecom Regulatory Authority of India, TRAI, Act, 1997. 12 www.visioneers.nwa.visioneers.in Copyright. Key provisions of the Act. Key provisions. Telecommunications Act 2023 assignment of spectrum allocation will be through auction and for specified uses on an administrative basis. For the first time, administrative allocation will be done of spectrum for the satellite broadband services in line with global norms. Appointments to TRAI Act has been amended to allow individuals with at least 30 years of professional experience to serve as the chairperson, and owe at least 25 years of professional experience to serve as members. Adjudication process: appointment of an adjudicating officer to conduct inquiries against civil offences. Appeals against the orders of the committee in connection to breach of terms and conditions may be filed with Telecom Dispute Settlement and Appellate Tribunal (TDSAT) within 30 days. Protection of users: central government may provide for measures to protect users, e.g., prior consent to receive specified messages, creation of do not disturb registers, and allowing users to report malware or specified messages. Right of way: entities building infrastructure can seek right of way, facilitating the use of property over public or private property. Powers of interception and search. Messages can be intercepted, monitored, or blocked on certain grounds, including security of the state, public order, and prevention of incitement of offences. Authorization for telecom-related activities. Prior authorization of central government needed to provide, operate, maintain, or expand new telecommunication services, and to possess radio equipment. Regulation of arts OTT platform will not be regulated under the Telecommunications Act 2023. Other provisions: Digital Bharat Nidhi. The bill renames the Universal Service Obligation Fund as Digital Bharat Nidhi and allows its use for research and development in telecom sector. Trusted Sources Regime, which came into being after the 2020 Indo-Chinese border skirmishes to stop imports of telecom equipment from hostile nations, is now part of the law. Some concerns highlighted with the Act. Privacy concerns: the provision of allowing interception and monitoring of the messages can be misused, leading to issues like data leakages. Also, the requirement of biometric verification for users may not be proportionate, and hence, may infringe upon the fundamental right to privacy. Lack of clarity in definitions. Definition of telecommunication services provided is broad and open to interpretation. This may take its ambit online platforms like WhatsApp as well. Delegated legislation. The government may add, modify, or remove offences in the third schedule to the Act by a notification. It has been debated that such changes should only be through an Act of Parliament. Conclusion. The Act straightens out several issues in the telecom sector, such as the issue of spectrum allocation. To further restore the health of the telecom sector and address the apprehensions, a multi-stakeholder approach should be taken towards its implementation. 13 WW 1.6 Abrogation of Article 370. Why in the news? A constitution bench of the Supreme Court recently upheld the validity of the Union government's 2019 decision to repeal the special status of Jammu and Kashmir, J&K, under Article 370 of the Constitution. More on the news. On August 5, 2019, the President of India promulgated an Order Constitution application to Jammu and Kashmir, Order 2019, which stated that provisions of the Indian Constitution are applicable in the state. This effectively meant that all the provisions that formed the basis of a separate constitution for Jammu and Kashmir were abrogated. With this, Article 35A2 was automatically scrapped. Parliament also enacted the Jammu and Kashmir Reorganisation Act 2019, which bifurcated the state into two union territories, UTs. The petitioners had challenged the constitutionality of these actions of the Union, against which the recent judgment was given by the Supreme Court. Article 370, a historical context instrument of accession, IOA. In October 1947, Maharaja Hari Singh, the last ruler of J&K, signed the IOA through which he agreed to accede his state to the Dominion of India. Temporary provisions for J&K, Constitution of India came into force on the 26th of January, 1950. Under the Constitution, Article 370 was placed in Part 21, titled Temporary and Transitional Provisions. Article 370, except for defence, foreign affairs, finance and communications, Parliament needed the state government's concurrence for applying all other laws. Further, it stated that except Article 1, which declared India as a union of states, and Article 370 itself, no part of the Constitution would apply to Jammu and Kashmir. The President of India could make any provisions of the Constitution to apply to this state with modifications or Article 370 itself could not be amended or repealed, unless the Constituent Assembly of Jammu and Kashmir consented to it. Article 35A of the Indian Constitution, it stemmed out of Article 370 and gave powers to the J&K Assembly to define permanent residents of the state, their special rights and privileges. Judgment and its rationale. Rationale. No internal sovereignty. The SC held that J&K did not retain any element of sovereignty after its accession to India in 1947. O Court relied on Yuvraj Karan Singh's, successor to Maharaja Hari Singh, proclamation, which stated that the provisions of the Indian constitution would govern the relationship between the J&K and India. Apart from Article 1 and 370 of the Indian Constitution, the court cited Section 3 of the J&K Constitution, which stated that J&K is and shall be an integral part of the Union of India. Nature of Article 370. The SC held that Article 370 is a temporary, transitional provision. O Court relied on historical context for the inclusion of Article 370 and the placement of Article 370 in Part 21 of the Constitution to conclude that it is a temporary provision. O Court held that the dissolution of the Constituent Assembly of J&K could not limit the powers of the President to abrogate Article 370. Constitutionality of presidential proclamations. The Supreme Court upheld the presidential proclamations of August 2019. The Presidential Order of 2019 amended Article 367 and declared that the expression Constituent Assembly of the State in Article 370(3) shall be read to mean Legislative Assembly of the State. Central issue was whether these actions could be taken by the Union assuming powers of the state when it is under President's rule. O Court held the consultation of the state government was not essential under 370(3), as the President had unilateral power to declare that Article 370 ceases to exist. www.visioneers.nwa.visioneers.in copyright symbol. Power of President during state emergency. SC held that declaration of state emergency and subsequent actions of the President should have reasonable nexus. Relying on judgment in S. Ubamai case, it also held that actions of President during a state emergency were open to judicial scrutiny. Elections to Legislative Assembly. Court directed the Election Commission of India to conduct elections to the Legislative Assembly of Jammu and Kashmir by the 30th of September, 2024. Court stated that restoration of statehood should take place at the earliest. Truth and Reconciliation Commission. The court recommended that the centre set up a Truth and Reconciliation Commission, just like South Africa did in its post-apartheid era. The commission would investigate and report on the violation of human rights both by state and non-state actors in J&K and recommend measures for reconciliation. Impacts of abrogation of Article 370. Extension of rights. All the rights enshrined in the Constitution of India and benefits of all the central laws are now available to the people of J&K and Ladakh. No separate symbols or laws. J&K no longer has its own flag, constitution, and its own penal code, called the Ranbir Penal Code. Ending exclusive property rights. Abrogation enabled centre to notify new land laws for the J&K, ending the exclusive rights of permanent residents over the land. Social justice. Provision given for the SCS and SDS in the rest of the country is also now available to the community in J&K. Local government. Constitutional status to local government through application of 73rd and 74th Amendments of Constitution to J&K. Rights of women married to non-locals. Abrogation allowed the issue of domicile certificates to the husbands of local women married to non-locals. Conclusion. With the judiciary upholding the abrogation of Article 370, it is important to foster economic development in J&K and ensure early elections for realization of democratic aspirations of people of J&K. 1.7. Expulsion of lawmakers. Why in the news? Recently, Lok Sabha in India has expelled one of its members accused of accepting gifts and illegal gratification. Similarly, the US House of Representatives has also expelled one of its members over criminal corruption charges. More on the news. Expulsion in Lok Sabha. Lok Sabha had constituted an ethics committee to probe into the matter of corruption and breach of privilege, contempt of the House. Ethics Committee report of LS found the member guilty of unethical conduct and contempt of the House. The House accepted the conclusions of the committee and later passed a motion that supported her expulsion as a member of Parliament. Expulsion in the US. An ethics committee report in the USA found the US lawmaker guilty of corruption and misspending campaign money, after which the House expelled him by adopting a motion. To know more about the Ethics Committee of Lok Sabha and ethics of lawmakers, kindly refer to Article 9.1 Ethics of Lawmakers in the October 2023 edition of Vision IAS Monthly Current Affairs magazine. Expulsion of lawmakers in India. The expulsion of an MP in India can be on a constitutional, as well as legal rules of the House basis. While the rules of the House provide for the suspension of MPs, members can also be expelled through these rules. 15. www.visioneers. Constitutional basis of expulsion. An MP found guilty of breach of privileges or contempt of the House can be suspended from the House or face expulsion. Parliamentary privileges are legal immunities enjoyed by members of legislatures, in which legislators are granted protection against civil or criminal liability for certain actions done or statements made in the course of their legislative duties. Article 105 deals with the powers and privileges of both houses of Parliament and its members and committees. Article 194 outlines the corresponding powers, privileges, and immunities of state legislatures and their members and committees. Contempt of the House is defined as any act or omission which obstructs or impedes either House of Parliament in the performance of its functions, or which obstructs or impedes any member or officer of such House in the discharge of his duty, or which has a tendency directly or indirectly to produce such results. Parliament is the sole authority to ascertain if there has been a breach or contempt of the House. No court is entrusted with this power. Article 122 of the Indian Constitution says parliamentary proceedings can't be questioned by the judiciary, although the courts have intervened in some cases. In the Raja Rampal case, 2007, the court upheld the expulsion of Raja Rampal, but noted that proceedings tainted by substantial illegality are open to judicial scrutiny. Legal basis of suspension and expulsions of MPs. To ensure smooth proceedings and maintain order, the presiding officer of the House has the power to force a member to withdraw from the House. In cases of extreme misconduct, the House may expel a member to rid the House of persons who are unfit for membership. Rules of procedure and conduct of business related to suspension in LS and RS rules in LS rules in RS Rule 373. It empowers a presiding officer to order an MP to withdraw during the remainder of the day's sitting. Rule 255. It allows the chairman to direct any member to withdraw immediately from the House for disorderly conduct. Rule 374. It allows the presiding officers to name the legislators, and then a motion can be moved to suspend the MP for a period not exceeding the remainder of the session. Rule 256. It allows chairman to name the members, disregarding their authority or abusing the rules. The House may then adopt a motion suspending the member for a period not exceeding the remainder of the session. Rule 374A brought in 2001 allows the Speaker to name an MP, who will then automatically stand suspended for 5 days, or the remaining part of the session, whichever is less. Unlike the Lok Sabha, under Rule 374A, the Rajya Sabha cannot suspend its members without passing a motion. Please note that expulsion and disqualification are not the same. The Constitution provides for both expulsion and disqualification. Under disqualification, member of the Parliament cannot contest the elections further, while under expulsion he or she can. 16 WW. Disqualification of members of either House of Parliament. Constitutional provisions. Article 102 of the Constitution of India provides for the disqualification of members under certain conditions: if he holds any office of profit under the union or state government, if he is of unsound mind and stands so declared by a court, if he is an undischarged insolvent, if he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state, is under any acknowledgement of allegiance to a foreign state, if he is so disqualified under any law made by Parliament. Criteria for disqualification under Representation of the People Act, 1951. A person will be disqualified if convicted and sentenced to imprisonment for 2 years or more. If an MP is found guilty of certain election offences or corrupt practices in the elections. If an MP has failed to lodge an account of his/her election expenses within the time. 10th Schedule, introduced in Constitution by 52nd Amendment Act 1985. The Constitution also lays down that a person shall be disqualified from being a member of Parliament if he is so disqualified on the ground of defection under the provisions of the 10th Schedule. 1.8 National Cadet Corps, NCC. Why in the news? National Cadet Corps, NCC, the largest uniformed youth organization in the world, celebrated its 75th anniversary in 2023. About NCC. NCC came into existence under the National Cadet Corps Act XXXI of 1948. Earlier, a committee headed by Pandit H.N. Kunzru recommended a cadet organization to be established in schools and colleges at a national level. Aims of NCC: to create organized, trained and motivated youth to provide leadership in all walks of life and always available for the service of the nation. To motivate the youth to take up a career in the armed forces. To develop character, commandership, discipline, leadership, secular outlook, spirit of adventure and the ideals of selfless service amongst the youth of the country. It's a tree services organization comprising the Army, the Navy, and the Air Wing. Headquarter, New Delhi. NCC Directorate. NCC at the state level is divided into 17 directorates, in which each state or group of states or UTs forms a directorate. Nature of the NCC program: voluntary. The students have no liability for active military service. NCC offers 3 types of certificates based on duration. Contributions of the NCC. Assistance during wartime. During the Indochina War, 1962, Indo-Pak Wars, 1965 and 1971, and Kargil War, 1999, NCC cadets provided instrumental help. They assisted various organizations in the states, like hospitals, Post and Telegraph Department, Traffic Control Police, communication systems, refugee camps, and families of soldiers. Social service. The NCC has been actively participating in social service activities like the blood donation drives, anti-polio drive, plantation drives, etc. NCC cadets recently led weeks-long Swakata Hai Sewa, a pan-India cleanliness and awareness drive encompassing various impactful events aimed at fostering a garbage-free India. Rescue and relief work. NCC cadets are the first to reach the affected location and provide selfless assistance to the victims during calamities like earthquakes, cyclones, floods, train accidents, etc. 17 www.visioneers.nwa.visioneers. OEG. During the Bhopal gas tragedy, 1984, NCC cadets immediately engaged themselves in evacuation of casualties, administering medicine, etc. Other contributions. Developing leadership and officer-like qualities among the youth. Increasing mutual understanding, trust, friendship and peace among the countrymen. NCC versus National Service Scheme, NSS. While both are voluntary in nature, there are certain differences. Conclusion. Empowered youth are pivotal for a nation's success. The NCC, by fostering character and selfless service, can significantly contribute to shaping this empowered youth, driving India towards a new India. 1.9 News in Shorts. 1.10.1 Lokayukta. The Maharashtra Legislative Council recently passed the Maharashtra Lokayukta Bill, 2022, replacing the Maharashtra Lokayukta and Upalokayuktas Act, 1971. Maharashtra was the first state to establish Lokayukta in 1971, followed by Odisha. Lokayukta is an anti-corruption authority constituted at the state level to look into cases of corruption against certain categories of public servants at state level. Its origin can be traced to the ombudsman in Scandinavian countries. In 1966, First Administrative Reform Committee, ARC, recommended the establishment of Lokpal at the centre and Lokayukta at the state level. The Lokpal and Lokayuktas Act, 2013 provides for establishment of the Office of Lokayukta through state legislation. To know more about Lokpal and Lokayuktas, kindly refer to Article 1.5 Office of Lokpal in March 2023 edition of Vision IAS, Monthly Current Affairs magazine. Issues faced by Lokayuktas owe non-uniformity. The structure of the Lokayukta and their capabilities are variable throughout the states. Difference between NCC NSS Ministry of Defence Ministry of Youth Affairs and Sports Year of Establishment 1948-1969. Aim to foster disciplined, selfless youth leadership for national service and military careers. Development of students' personality through community service. Established through National Cadet Corps Act XXXI of 1948, a central sector scheme. Uniform compulsory uniform for NCC cadets, no uniform prescribed for NSS volunteers who can join. Junior Divisional Wing, students from schools of 13 years or more of age. Senior Divisional Wing, students from colleges, and 11 and 12 classes. 11th and 12th class students of technical institution, graduate, and postgraduate at colleges and university level of India. 18 www.visioneers.nwa. E.g. Rajasthan, Maharashtra, established both the Lokayukta and the Upalokayukta, but Uttar Pradesh, Himachal Pradesh, established just the Lokayukta. Some Lokayuktas not in line with the 2013 Act. Few states thus have not amended their Lokayukta Acts to bring them in line with the Lokpal and Lokayuktas Act, 2013. Limited authority. It can suggest punishment against the offender, but it is up to the state to accept or modify the suggestions. 1.10.2 Impeachment in US and India. US House of Representatives voted to formally open an impeachment inquiry into the president. Impeachment in US and India. Specific tie in USA, India. Applicab ilita President, Vice President, and all civil officers of the federal government are subject to impeachment. Only President, under Article 61 of Constitution. Grounds of impeachment. Treason, bribery, or other high crimes and misdemeanors. Violation of the Constitution. Process charges. Any member of the House of Representatives can bring charges of impeachment. Charges preferred by either House of Parliament, provided such charges are signed by at least 1/4 of members of the House. Voting, resolution. Voting simple majority of the House of Representatives. Presiding officer for trials, Chief Justice of U.S. Needs to be passed by not less than 2/3 of total membership of each House. Once passed in one House, it is sent to other House, where an investigation into the charges proceeds. Vote on resolution. Presiding officer. Presiding officer of respective houses. Consec ends impeachment serves as an indictment, not removal. After impeachment, Senate, upper house, is convened like a court. President can only be removed if at least 2/3 of Senate votes for it after the hearings. Andrew Johnson, Bill Clinton, and Donald Trump were impeached, but none were removed. Impeachment results in the removal of the president from office. No president has been impeached so far. 1.10.3 Two bills on Jammu and Kashmir, J&K, receive President's assent. J&K Reservation Amendment Act, 2023. OD amends the J&K Reservation Act of 2004, which provides reservation in jobs and admission in professional institutions to members of scheduled castes, scheduled tribes, and other socially and educationally backward classes, SEBC. Amendment substitutes weak and underprivileged classes with other backward classes, as declared by the UT of J&K. The definition of weak and underprivileged classes is deleted from the Act. J&K Reorganization Amendment Act, 2023. OD amends the J&K Reorganization Act of 2019. 19W. Key highlights of the Act increases the total number of seats to 114 from 107. Small black square. As per the J&K Reorganization Act, 24 seats of the Assembly will remain vacant until the occupation in Pakistan-occupied Kashmir ceases. Small black square. Therefore, the effective strength of the Assembly is 83, which the amendment seeks to increase to 90. Reserve 7 seats for scheduled castes and 9 seats for scheduled tribes. Nomination by Lieutenant Governor in Legislative Assembly small black square, up to 2 members from the Kashmiri migrant community. 1 must be a woman, small black square, 1 member representing displaced persons from Pakistan-occupied Jammu and Kashmir. 1.10.4, Post Office ACT, 2023. President gave assent to Post Office Bill, 2023 to revitalise post offices. Post Office Act, 2023 will replace Indian Post Office Act, IPOA, 1898. IPOA, 1898, was enacted during the tenure of Viceroy Lord Elgin II, 1894 to 1899. There was need of a new act as IPOA, 1898 addressed mainly mail services provided through the post office. Also to ensure better governance for post offices, as their services have diversified beyond mail such as India Post Payments Bank, insurance schemes etc. With time, they have emerged as a vehicle for delivery of a variety of citizen-centric services. Key highlights of the Act. Powers to intercept postal articles. It empowers officers to intercept, open or detain an article which is being transmitted through post on certain grounds. Grounds include security of the state, friendly relations with foreign states, public order, emergency, public safety etc. Exemptions from liability. PO will not incur any liability with regard to its services, except any liability prescribed through rules. Other, Director General of Postal Services will be appointed to head India Post. 1.10.5, Fast Track Special Courts, FTSCS, Scheme. Union Cabinet approves continuation of Fast Track Special Courts, FTSCs, scheme until March 31, 2026. Launched in 2019, FSDCs is a centrally sponsored scheme and implemented by Department of Justice, Ministry of Law and Justice. Central share is to be funded from Nubaya Fund, aimed at enhancing the safety and security for women in country. FTSCs, designed as dedicated courts, were established for hearing rape and protection of children from sexual offences, Act POCSO Act cases. Enactment of Criminal Law, Amendment, Act 2018, which included stringent punishment, including death penalty for rape offenders, leading to the creation of FTSCs. FTSCs are linked to National Judicial Data Grid. 761 FTSCs, including 414 exclusive POCSO courts, are operationalized in 30 states and union territories, which have resolved over 1.95 lakh cases. 20 www.visioneers.nwa.visioneers.in Copyright symbol Vision IAS. Concerns associated with FTSCs, lack of IT infrastructure, and special training provided to judges, inadequate number of judges etc. 1.10.6, Gram Manchitra. Ministry of Panchayati Raj, MoPR, is promoting Gram Manchitra to facilitate spatial planning by the Gram Panchayat. About Gram Manchitra. It is a geographic information system, GIS, application, launched by MoPR in 2019. It has been developed by National Informatics Centre, NIC. It helps to perform spatial planning at Gram Panchayat level with use of geospatial technology. It provides single geospatial platform to better visualize various developmental works and provide a decision support system for Gram Panchayat development plan. 1.10.7, Errata. In October 2023 Monthly Magazine, Article 1.2 Criminalization of Politics had mentioned lifetime ban for convicts from polls. Election Commission of India had mentioned it in the electoral reforms proposals published by it in 2004 and 2016. It is clarified that such ban was proposed by the Election Commission for convicts for serious offences.